Thank you, Pat. It's good to be with you. Thank you for having me on again. The book is designed really to bring people inside the Supreme Court. Each chapter of the book addresses a different constitutional liberty, and it's from the perspective of a litigator. You know, before I was in the Senate, what I did for a living is argue cases in front of the U.S. Supreme Court, and so each chapter tells war stories to try to bring people behind the scenes. You know, a lot of people know the court's important, but it can be confusing. It's hard to understand what's going on there. This book is designed to make it simple and clear and help folks understand the stakes of the battles they're playing out there from the inside, what's going on with the justices, who the justices are. And what is stunning as you go from chapter to chapter to chapter on free speech, on religious liberty, on the Second Amendment, is on each of our fundamental liberties. Virtually all of the major landmark cases were decided 5-4, that we're just one vote away from losing those precious liberties.
You know, you've talked about the fact that when Republicans appoint somebody, that their nominees turn left almost invariably, and the Democrats appoint them, they stay truly to the left. And there's one case that I was in law school at Yale, and they decided called Griswold versus Connecticut, which is the most absurd nonsense about emanations and all. You mentioned all that, and there's nothing in the Constitution about condoms. I mean, it just isn't there. But you've got to find emanations and penumbras out of the 14th Amendment. How do they do that?
Well, Pat, as you know, what you're laying out is the case law that built up to Roe versus Wade. And Roe versus Wade in 1973, I've got an entire chapter in the book on life. And it describes how the Supreme Court fundamentally changed in 1973 when it issued Roe. Prior to 1973, questions of abortion had been decided at the state level. And different states had different laws, and you could debate it. You could debate it in the legislature. You could go and fight to defend the right to life and convince your fellow citizens and have the laws reflect your values. In 1973, the Supreme Court said, the voters, your views don't count, you don't get to speak on it. And you know, you used a phrase that the lawyers out there will recognize, but most people, it's an odd phrase. You said emanations and penumbras, and it's actually where Roe came from. So the reasoning, they said, okay, the Constitution doesn't speak to abortion at all. But what the court said is, well, certain rights in the Bill of Rights have emanations. Basically, they glow. And those emanations cast penumbras. Now, penumbra is just a fancy 10-penny word for a shadow. And within those penumbras, from the emanations, that's where we find the right to unlimited abortion. I mean, it was fiction writing. It had nothing to do with the Constitution. It was 9 justices who were legislating, and one of the things I talk about in the book is that decision ended up politicizing the court. It's why we have these knockdown, drag-out battles over Robert Bork and Clarence Thomas and Brett Kavanaugh, because the left made a decision, really starting in the 60s, moving into the 70s, that democracy was too hard, that it was too hard to actually convince your fellow voters of your views. It was much easier just to get 5 unelected lawyers in black robes decree a radical outcome for the country. And that started us down a very dangerous path. And the left, look, this election we've got in November, the stakes we've got here are fundamental rights. On the question of abortion, we're one vote away from the court striking down every restriction on abortion across the country and mandating the Democrats' policy position, which is unlimited abortion on demand up until the moment of birth, partial birth abortion with no parental consent, no parental notification. And
next video, Homeland Security launches new center to investigate, prosecute human trafficking crimes.
There was one case coming out of Louisiana where the court struck down a very simple question about having informed consent before an abortion, and they said, no way, you've got an unlimited right to abortion. And what you say is exactly right. It was federalized. it should be state police power, and this was federalizing this thing, and it's caused chaos in our society ever since.
It's exactly right, and it's about power. You take another example, the chapter on religious liberty. And I've been fortunate, many of the big landmark cases I help litigate personally. And so I tell the story from the inside. So I tell the story, for example, of the Ten Commandments monument that stands on the state capitol grounds in Texas. It's been there since 1961. And an individual plaintiff, an atheist, and actually a homeless man, saw the monument and got offended, and he filed a lawsuit. He argued you can't have the image of the Ten Commandments on state grounds. The case went all the way to the U.S. Supreme Court. Texas defended the monument. We won 5-4. There were 4 justices ready to say, send in the bulldozers and tear down that 60-year-old monument because of a radical view from the left that God has to be removed from the public square. And I'll tell you something amazing, Pat. Do you know how many times the image of the Ten Commandments appears in the courtroom of the Supreme Court of the United States?
How many?
43. 43 times. The Ten Commandments appear twice, carved into the wooden doors as you walk out of the courtroom. They appear 40 times on the bronze gates along the sides of the courtroom. And then up to the left of the justices, carved onto the frieze, there's a frieze of great lawgivers. And there is Moses holding the Ten Commandments, the text still legible in Hebrew, looking down over the shoulders of the justices. And 4 of the justices were willing to say, in effect, bring out the chisels and sandblasters. We can't acknowledge the Ten Commandments anymore. It is a radical, anti-religious view. It's the same view that wants to go after the Little Sisters of the Poor. It's the same view that is going after pastors. And our fundamental right, our first liberty to worship God free of government getting in the way, we're 1 vote away from losing that.
Well, you know, that Hugo Black wrote that decision, and he picked up a letter from Thomas Jefferson, said there was a wall of separation, and he said, we will not permit its breach. And he was a member of the KKK. He was also a strong, well, he was anti-Catholic. And to see that wall of separation, that's what they keep talking about. There's nothing in the Constitution that sets up a wall of separation between church and state that I know of. It's in the Soviet Constitution.
Well, you're right, and the letter in question, Thomas Jefferson was writing to the Danbury Baptists, and the phrase separation of church and state, it doesn't appear in the Constitution or the Bill of Rights or the Declaration. It appears in this private correspondence from Thomas Jefferson, and I talk about this in the book and explain what it really means. What Jefferson was talking about was a wall to protect the church, was a wall to keep government out, was not having government be able to intrude on the internal matters of the church. And that is a one-way wall. It wasn't a wall trying to keep Christians out of public life. It wasn't a wall trying to stop the exercise of our faith, but it was instead a defensive wall saying the government can't come in and control your church. You know, several years ago, you may remember in Houston, the mayor of Houston subpoenaed 5 pastors in Houston and demanded to see their sermon notes on everything they had preached on homosexuality. And at the time, I was deeply upset about it. I called my pastor. Heidi and I are members of First Baptist Church in Houston, and our pastor's Greg Mott. And I said, Pastor Greg, have you seen what happened with the subpoenas? He said, yeah, I've seen it. And he said, I've been praying about it all morning. And I said, Pastor, I'd like to do a rally of pastors throughout the city against this intrusion into religious liberty. And I said, I'd like to do it tomorrow, Thursday, at 11 a.m. And I wanted to ask, can we do it at the church? Would you be willing to host it? And Pat, my pastor begins laughing. And he said, you know, Ted, a month ago, God laid on my heart that we needed to be praying for our city. He said, a month ago, I invited pastors throughout the city to gather at the church. He said, Ted, tomorrow, there are 50 pastors throughout the city of Houston coming to my office tomorrow at 10 a.m. and both of us just kind of stopped and just, said, wow, God is amazing when he works. And so the next day, I joined those pastors. We spent an hour on our knees praying for our city from 10 to 11. And then at 11, we went out and did the press conference together. And we stood as one. We said, when you subpoena one pastor, you subpoena every pastor. And Caesar has no jurisdiction over the pulpit. And we stood up, and what happened, and it's a great encouragement for believers out there, is the sunlight and the heat and the attention became too much, and the city of Houston backed down and they withdrew the subpoenas. These fights we can win, but we've got to be willing to actually stand up and defend our constitutional rights and our religious liberty.
Let me ask one thing about this coming up. The minority leader of the Senate has said this is the most unconstitutional hearing in history. There's nothing about the confirmation of Amy Barrett that would be unconstitutional, is it?
No, not remotely. And in fact, the confirmation of Judge Barrett, tomorrow the Judiciary Committee is going to vote to confirm her, and then the full Senate will confirm her on Monday. That is consistent with 2 centuries of precedent. So the situation we have now, a Supreme Court vacancy during a presidential election year, that's actually not a new thing. That has happened many times in our nation's history, 29 times to be exact. So 29 times there's been a Supreme Court vacancy during a presidential election year. Presidents have nominated someone to those vacancies all 29 times. Doesn't matter if you're a Democrat or a Republican, if you're a president, you make that nomination. What has the Senate done? Well, 19 of those times, the president and the Senate were of the same party. Of those, the Senate confirmed 17 of them. 17 out of 19. The precedent for 2 centuries is if the president and senator are of the same party, typically that nomination is confirmed. How about the other 10? The other 10, the president and the Senate were of opposite parties. In those situations, the Senate has confirmed only 2 of them. That's the precedent as well. So in 2016, when Barack Obama made a nomination, you had a Senate that was of a different party, and we exercised our constitutional role as a check and balance to prevent filling that seat. Likewise, in this instance, the American people, they elected Donald Trump promising to nominate principled constitutionalists to the courts, and they elected a Republican majority promising to confirm principled constitutionalists to the court. So on Monday, when we confirm Judge Barrett, we will be fulfilling our promises to defend the Constitution and Bill of Rights, and it's the voters that have made that decision.
Oh, when they were considering a vacancy, I must say that you were my candidate. I got pretty close to the president to try to see if he wouldn't put you in, because I thought you would be a voice of reason and a stabilizing force in the court. If you, is there any possibility if the president wanted to put the next judge on that you might accept, or if he was offered to you?
Well, Pat, I appreciate that very much. That is very kind of you. I can tell you it's not the desire of my heart. It's not where I want to serve. It's one of the things I talk about in the book, One Vote Away, is each of the 3 vacancies that has occurred under President Trump, he and I have had very serious conversations about the court. And each time I've told him no, that I don't want to serve on the court. He just recently put out a new Supreme Court list, and he very kindly included me on the list of justices he might appoint. I'm grateful for that confidence. I'm certainly grateful for your confidence as well. I gotta say, a lot of people find it strange that I don't want to serve on the court. Given my background, given how much time I've spent in front of the court, that seems odd to them. And let me explain why I don't. A principled judge stays out of political fights. A principled judge stays out of policy fights. If I were ever a judge, that's what I'd do. I'd stay out of these fights. I don't want to stay out of them. I think there is a desperate need in the political arena. We need people to fight for our liberties.
We're going to lose our satellite feed with you in just a minute. This is a tremendous book, ladies and gentlemen. I want to tell you, I was just fascinated to read it. It is so well done, and it's called One Vote Away. It's Ted Cruz's book, and I think you can get it wherever books are sold, and I recommend you do it. And Ted, thank you so much for being with us. I hope you can come back. It was wonderful talking to you. God bless you.